Hello, and welcome to the Law School Toolbox podcast. Today, we're going to be talking about what lawyers argue about. And this is going to help you be ready for your law school classes and your exams. Your Law School Toolbox hosts are Allison Monahan and Lee Burgess. That's me. We're here to demystify the law school and early legal career experience so you'll be the best law student and lawyer you can be. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, the Catapult Conference, and the Trebuchet Legal Careers site. Allison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on iTunes. And if you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on lawschooltoolbox.com, and we'd love to hear from you. And with that, let's get started.
Welcome back. Today we're talking about a big picture topic. What do lawyers really argue about? Because if you're a new law student and you're starting to feel overwhelmed by the idea of reading piles of cases before class, talking about them in class, doing something known as outlining, and then taking an exam, you're not alone. Sometimes to make sense of it, you need to step back and take a look at the big picture because it can bring clarity to the work that you're doing. So let's take this step back together and talk about what lawyers actually argue about. Lawyers argue for a living, right? Well, they typically argue about three distinct things. Lee, what are those?
First, lawyers argue about the facts. Lawyers often disagree about what the facts are in a given case and what they mean. So in other words, what legal implications a certain fact has, and typically what category something might fall into. Second, lawyers argue about the law. They often disagree about what the law is and how the law should be applied to a given factual situation. And lastly, lawyers argue about policy. We disagree about what the law should be and how a case should be decided by the court. So if you're attending law school classes, take a moment to think about whether these three different argument types were discussed in your last class, because I bet more often than not, they were.
Right, so basically we've got facts, law, and policy. And you might have heard the adage, if the facts are against you, argue the law. If the law is against you, argue policy. So it's kind of the way that you go. And if the facts are in your favor, you focus on those. If the law is in your favor, you focus on that. If you have to throw your hands up and say the facts and law are both not really in your favor, then you argue about policy. It's kind of the last resort.
That's just a good thing to keep in mind, too, for an exam, that oftentimes you argue all of these things, depending on what the situation is on exam.
Definitely. So let's dig a little bit deeper into what we mean by this, because it still sounds a little abstract, I think. So if we're talking about the facts, here's like a real life example. Well, real life, sort of. Here's a factual situation that's based on an actual California bar exam question. So the facts in the hypothetical, they state that a defendant entered an unlocked garage door at night to steal computers out of a victim's home office that was located in that garage. Now, you probably may not know this yet, but the traditional rule for burglary is that it requires the breaking and entering of a dwelling at night with the intent to commit a felony. So if we were to break that law down, we'd have to show breaking and entering of something that counts as a dwelling at night with the intent to commit a felony. So if we look at our facts, we know that the defendant entered an unlocked garage door at night to steal computers out of the home office. So what is some factual ambiguity that we might pick out here based on our understanding of the law?
This might be the first time in the podcast that we truly become nerdy, because I get really excited by this example, because I love talking about this ambiguity. I know, it's really sad. But okay, I think it's the first ambiguity that I always see in this fact pattern is this idea that it was an unlocked garage door. It wasn't just a garage door, it was unlocked. And so...
Why does that matter?
Well, if the rule says that I have to break, it requires a breaking and entering, and not just an entering, that means that I kind of have to break something, I would think.
Okay.
And I'm not sure that entering an unlocked garage door would be a breaking. I think it's debatable.
Right, when it might also depend on, was the garage door open or closed? Is there a difference between a closed but unlocked garage door and an open garage door? Because I think If you think of these things on a continuum, I think you could make an argument if the garage door is standing wide open, pretty clearly probably not a breaking and entering.
Right.
If the garage door is locked and closed and you break into it, probably a breaking and entering. But this is a point. There's this ambiguity in the middle where we can assume probably from the question that the garage door is shut, but it's not locked. So that's an example of where the facts are intentionally ambiguous. And what does that give you the opportunity to do if you're writing an answer here?
Oh, it allows you to argue both sides, which is just exam gold.
Yeah, absolutely, right? So you can say, well, the fact that the door was closed would suggest that arguably there was a breaking and entering. However, the fact that the door was unlocked would cut the other direction. Anything else that you think is ambiguous factually in this question?
Well, the thing about this question that's also very interesting is the choice of the people who wrote the question to make it a garage. This home office is in a garage, and that definitely links to whether or not this is a dwelling, because I think it is also debatable whether or not a garage could be considered a dwelling. Now, a lot of it could depend on how the house is set up. I mean, we have here in San Francisco, most of our garages are the first floor of our homes, if you have a garage. So that seems to be maybe arguing more along the lines that it was part of a dwelling. But on the other hand, a lot of places have garages that are separate from the home. So would that be a dwelling? Or since nobody lives in the garage, does that make it part of a dwelling? What about the fact that it was used as an office and not even used, necessarily as a home? It was called a home office, which might also give you facts to argue about. So there's a lot here with just the word garage that creates ambiguity on this kind of spectrum of like what is exactly a dwelling and what is exactly not, that you could argue and get a lot of analysis points on an exam.
But Lee, don't you think they just accidentally said it was a garage?
Oh, my favorite question. No, never. When people write, professors or bar examiners, when you get there, when they write these fact patterns, they actually fight or struggle over these individual words. Garage and home office and unlocked door, all of that stuff was inserted into the question to very specifically solicit this debate and create this ambiguity to give you something to talk about. This is not set up to be a slam dunk answer.
Right, well, because it's interesting. I think I might have actually missed the fact that there was an unlocked garage door because I would have been so focused on the fact that we were talking about a home office in a garage.
Mm-hmm.
So I think you might have done better answering this question than I would have done, because I would have spent all of my time talking about whether the garage is a dwelling. And I think I probably would have missed the fact that it was an unlocked garage door, and I probably wouldn't have talked too much about whether there was a breaking or entering.
Which is something that we often talk to our students a lot about, is when you are arguing the facts and you get a fact pattern, this would just be, one sentence and a part of a much longer fact pattern, is you really have to go word by word and like sometimes circle or check off words as you've thought about them and kind of in your brain discuss whether or not they have additional meaning, whether they're going to give you something to really talk about and create robust analysis, because it is awfully easy, especially under time pressure, to skip over facts and just kind of discard them as not important when they probably are important, because, words in a fact pattern are typically if it's a well-written fact pattern, have been very thoughtfully included.
Right, because the point is lawyers are precise, and you're learning to think like a lawyer, and a large part of that is thinking with precision. And class is really where you work on this legal precision. I mean, some people sit in class and they just find it absolutely maddening because there's never an answer. There's always a different way to look at things. Your professor is constantly giving you hypos. Well, what if instead of being a garage that's attached to the house, it was a garage that is separate from the house? Well, what if instead of being a garage that was separate from the house, it was an in-law unit in the back, and that in-law unit was used as a storage space, or that in-law unit had someone living in it? Or, whatever it is. And people can just find this maddening. I mean, how do you suggest students deal with that?
I think you really have to be in the right frame of mind that you can accept the fact that these fact patterns create ambiguity. And the ambiguity is really where the magic happens for lawyers. What makes a good lawyer is one that can see the ambiguity and then argue their side with the most, force and precision.
But are we just trying to get the right answer?
Well, the problem is there is usually not a perfect right answer. The answer is usually the debate
here, right?
That is the answer.
Well, but I mean, here's either garage is either a house or it's not, right?
Well, not necessarily, right? It all depends, which is what comes up for us all the time. It depends, right? I might need more information. But the best answers are really showing your understanding of that kind of it depends of an answer. It's the exams that you're going to write, and oftentimes the law that you're going to practice is all in the gray area.
Right. It's interesting. I remember when I was a TA, at some point, I was talking with one of my fellow TAs, and a student asked a question or whatever. And we realized that the answer, or that same question, had appeared on our final exam. And it was a take-home exam, so both of us had a copy of it. And we said, oh, no problem, we'll look up the answer, because we're both TAs, and we both have our exams. So clearly we must have, figured out the right answer. And it was very interesting, because when we looked at our 2 exams together, our conclusions were completely different. Mm-hmm. And both of us were TAs for the class. So making the point that the answer does not actually really matter in a lot of cases.
It's the journey to get to the answer that's much, much more important. And that's really that thinking of it like a lawyer, which is something you're probably hearing in your law school a lot. And that's training you to think like a lawyer is what the professors want to see. They want to see, do you have the ability to do legal analysis? Can you argue the facts? Can you get comfortable with ambiguity and stand in different parties' shoes and see how the arguments change based on, what outcome you're going for.
Right. The other thing to think about, too, is not every question is ambiguous. So, for example, in this question, there are certain elements of burglary that are very clearly met, right? Like we're told, for example, that this happened at night.
Right.
So on an exam, do you skip that entirely because it's so obvious, or do you spend half a page talking about it? What do you do with something like that that's kind of more of a slam dunk, like obvious issue?
You just get in and get out. You say, the facts tell us that the burglary happened at night, or the alleged burglary happened at night, therefore that element's met. Done. I mean, there's no ambiguity about it being at night. If it was at dusk...
So you do not write half a paragraph.
No. If it was at dusk, or if it was at like 5 in the morning, or 5:30 in the morning, and so you're not sure if that is at night, but if it tells you it's at night, just say, thank you, fact pattern, that was very nice and clear. I will just make that point and move on quickly. You're not going to get a lot of points for talking about that.
No, but you're going to get some, so you don't skip it. But I think your point too about it, what if it's happening at 5 in the morning? That's something different that would be in the fact pattern that should cause you to think, well, do we know what season it was? Mm-hmm. Because if it's summer, do we know what location we're in? I mean, if I'm in Iceland in the middle of the summer at 5 in the morning, it's light. If I am somewhere else in the world in the winter, maybe it's not. So these are the things that something that subtle, the difference between saying it happened at night or it happened, at a certain specific time. If it's a specific time, something should be triggering. Why was I given this information? Do they want me to talk about something in this fact pattern? Yeah.
So look, we gave you one sentence about this fact pattern, and we just had this long conversation about the facts. That's how this works. It doesn't take a lot of fact pattern to create a lot of ambiguity to talk about.
Yeah, so what are the things that really people struggle with here? I mean, I think a lot of people struggle with this whole concept of ambiguity and figuring out when something is ambiguous and when it's not ambiguous. Mm-hmm. The difference between night or the unlocked door. Right. So you have to be really careful when you read the facts. And then the other thing people really struggle with is they want to ignore the ambiguity and just jump to the conclusion.
Yeah. And that's such a huge mistake. If you're listening to this and you've already been through a round of exams, you might have gotten the feedback from a professor that you are too conclusory, which is oftentimes really puzzling to folks because they're not really sure what that means. And oftentimes what it means is that you did not discuss the ambiguity. You just skipped to the end and you said, hey, this was clearly burglary, period.
Right. And I think sometimes that happens when people don't write down what's in their head.
Mm-hmm. We do see that a lot. They say they made the argument in their head. They just didn't show the professor that they had the argument in their head.
Right, or they made the argument back and forth in their head, and then they decided which side had the better argument, and then they wrote down the answer.
Yep.
But the point is, you've got to write down that back and forth in your head so that your professor understands what you're thinking.
We often talk about it's like going back to high school math. when I had math teachers who wouldn't give you points unless you showed all your work. Like if you don't show your professor all of your work, you don't get the points.
Right. And in a way, it's sort of similar to math because we're talking essentially about logic here. What is each step in the chain of logic? You have to go through each step and not just sort of jump to, the answer.
Right.
Well, should we move on to the law?
Yeah, let's do that. So let's continue with our same example of our burglar. The rule that we were talking about is the traditional rule for burglary, which is another way of saying it's the old rule. And there is a more modern rule for burglary, which means it's the newer rule, which is that there needs to be a breaking and entering of a structure with the intent to commit a felony. So this rule changes the analysis, right? Because we've removed a few of the requirements. Night is not mentioned, but even though night was a slam dunk issue, it's not mentioned. But we also have some new words here. We have structure, where it's the breaking and entering into a structure. So, Allison, how do you think this changes our analysis of our burglar?
Well, I think it definitely makes it easier to figure out whether there's a burglary. I mean, if any structure counts, then we're not concerned about whether this was a dwelling. Clearly, the garage office is a structure. So I think it just makes the outcome a lot more clear. So even if the defendant might not have been found guilty of burglary under the traditional rule, because the court might have found that the garage office was not a dwelling, he would be found guilty under this more modern approach. So the court might actually have to decide which law to follow because they might not know what the precedent, we might not be told what the precedent is. So when you have these sort of shifts in the law, often on an exam, you'll be intentionally told, the court's in this state of, whatever, state of panic or whatever, if your professor's feeling funny. The courts of the state of panic have not decided which approach to accept or which approach to follow. So what that's doing is inviting you to go in both directions. It's inviting you to do the analysis under the traditional rule and say, well, it's very ambiguous about how this outcome might end up, and then to do the same analysis under the modern rule. And you say, well, under the modern rule, it's pretty clear cut. He's probably guilty of burglary. And this is actually an example we can get to later, but this is where you might bring in a policy argument. I mean, in this case, I'm not sure there's a huge policy argument one way or the other than the modern law probably being simpler and putting more people in jail, which you could argue about whether that's a good thing.
Right.
This example where the shift in the law might bring in some policy arguments. But basically, the court would have to decide whether to change the traditional rule. And your role as a lawyer, depending on which side you're on, if you're arguing for the defendant, you're going to say, no, Your Honor, the modern rule is bad for whatever reason.
Right.
Shouldn't be followed.
Right. It's too expansive.
Right.
It shouldn't be applied to the situation. There's a slippery slope. Like you start to get kind of a list of these possible arguments that you can make.
Right. And if you're the prosecutor, you're going to say, look, Your Honor, this is ridiculous. Like, what difference does it make if he broke into a garage that happened to be used as a part home or into a garage that wasn't used as a part home? Like, this is silly. It's just a structure. He broke into it. He committed the crime. He should be charged with burglary.
Right. Exactly. So this often comes up too in contracts, which if you're a 1L, you're probably taking a contracts class. And this kind of what law should be applied, I see come up over and over again when you're talking about applying either the common law to a contracts question or the UCC, which is the Uniform Commercial Code. And oftentimes the outcome of the case can really depend on which law is applied, even though the rule just sounds simple to make this determination, which is you should apply the UCC to all contracts dealing with the sales of good and the common law to all other contracts. But you are likely not going to be surprised to learn that the nature of the contract sometimes can create ambiguity. So
definitely.
Yes. So an example for this would be, what if you have a contract to build a fence, but the majority of the contract price is actually just for simply the supply of the wood to build the fence, not the labor to actually build it. So then how can you decide whether or not that is a contract primarily for the sale of goods or a contract under the common law, which would be a contract for a service? If you saw this on an exam, you might find yourself arguing which one should apply.
Yeah, absolutely. And the thing about the UCC is oftentimes the outcome will be different depending on whether you apply the common law or the UCC law. So you might think like, oh, who cares? It doesn't really matter. Like sale of goods, sale of services, like why do we even care about this? It can have a really big impact on the outcome of the case.
So this is going to come up a lot in your law school classes, maybe less in practice, because I don't think the choice of law is something that you see as often when you're practicing law, at least not the type of law that I was practicing, but it comes up on almost every single law school exam. Wouldn't you say, Allison?
Yeah, absolutely, because it's so easy to lead students down the wrong path. Because if you write your entire exam answer thinking that you're talking about a common law contract and your professor thinks that you should be talking about the UCC, well, that's pretty easy to curve because you're going to be at the very bottom of the curve.
Yep. So why do students struggle with arguing about the law? It seems kind of clear cut.
Well, I think there are a couple of reasons. One, it can just be difficult to keep track of all the different ways that the law varies. So, it's annoying not just to have to learn about battery, but to have to learn about a traditional rule for battery and a modern rule for battery. Or, if we're talking about contracts, not just to have to learn the mailbox rule, but to have to learn the common law mailbox rule and the UCC rule, and to keep straight where they're going to have a different outcome. So I think it can, you can use tables and things like that. But I think, evidence is another one. If you're looking at, say, distinctions in evidence between like a state and a federal rule, there's all these places that things like this pop up. And I think it's important to have a strategy when you encounter these types of situations for keeping track of it. Crim law is another one. I mean, anything where you have a common law plus a statutory or sort of semi-statutory law. So something in crim law, it might be the model penal code. And different professors teach things differently. So some of them might not care about that. Some of them might be all about the model penal code. Mm-hmm. But you need to have some sort of strategy, like a table or something like that, to keep track of these distinctions because they're almost certainly going to be tested because they're easy to test and most people will forget about them.
The other thing you want to watch with about, traditional versus modern rules or distinctions between, like a model penal code and California state penal code is that sometimes your supplements won't always talk about all of these different legal rules. They might just focus on one approach. And if your professor chooses to talk about more than that one approach, you are wise not to just get suckered into what your supplement might say or your commercial outline and ignore that secondary approach. So I had a student that I worked with once whose professor really wanted them to know the model penal code and then the California penal code and where it was different.
Which I'm not sure I even knew that existed.
The model penal code?
No, I know that exists.
Or the California...
Having gone to law school in New York, I'm not sure I knew the California penal code existed.
Okay. There is a California... And you didn't work in like a DA's office or anything like that?
No, I didn't. And I barely studied for the California bar. Yeah. So this has escaped my attention until today.
Well, California has its own criminal law rules. And so, for instance, I went to school in California, so my class was very focused just on the California rules for homicide and things like that. But this one student's professor really wanted them to appreciate both and the differences. And she really struggled because most, criminal law supplements aren't going to call out those distinctions. But she just had to come up with other ways to learn that information and still needed to learn both for her class. It was a very challenging exam, actually, to ask your students to do both. Comes up a bit more frequently with things like evidence. If you go to school in California, typically they will teach you the California rules of evidence as well as the federal rules of evidence, which is good because both are tested on the bar exam. But again, even if you pull out an evidence supplement, typically it's not going to talk about the CEC and the FRE. You're going to have to do some of that work yourself.
Yeah, and one good way to keep track of these is to always color code. So, for example, if you're typing in Word, maybe you make in your tables or even in your outline, every California rule is red and every federal rule is black because that can actually trigger your memory on an exam because you literally remember seeing the color and it can help you keep them straight.
Right. Or if you have an open book exam, then you can skim for those areas where there are distinctions, which is also really helpful.
Yeah, or ideally you've got them all in one place. Like in contracts, for example, if you have an open book exam, you probably want to have a table that lays out all the main distinctions between the UCC and the common law so that you can make sure that you're talking about them.
Yeah. So basically, the stuff is not clear cut. It takes a lot of organization. It takes some careful studying and practice, so you know when to apply these different rules and how they are different. And sometimes these distinctions can be pretty minor, so it does take some time to really learn them. So don't leave this stuff to the last moment to study. You want to focus on different ways to argue the law throughout the semester, and listen to your professors when they talk about these comparing two different approaches in class, because if they spend a lot of time on it, it's highly likely that it's going to show up on your exam.
Right, and it's often outcome determinative in the sense that which rule you apply determines the answer.
Yep. So don't let this one go, guys.
Yeah, don't just think you're going to figure this out later. Don't think it's just junk you have to somehow not worry about.
Exactly.
If there is a distinction, odds are pretty high it's going to show up on your exam.
Yeah. Now, what about policy? Because this is something that I think a lot of people ignore. We talked about it a little bit, where it might come up between picking what law to apply. But could you tell us a little bit about how policy arguments work in your law school classes?
Yeah, I mean, different professors care about this to a different extent, and certainly different classes, you're more likely to encounter policy arguments. I mean, certainly if you're taking constitutional law, that's sort of all about policy arguments, but other classes, it can be really common too. I mean, like torts, for example, there are typically a lot of discussions of policy, things like the Coase theorem about who should have to pay for certain problems. And this is a situation where I think it can be difficult for a lot of students because it's not a lot of the policy arguments, particularly coming out of the sort of law and economics movement, are not necessarily that intuitive. So it might seem weird to you to be forced to argue that a factory that's polluting should be paid not to pollute by the people whose land it's polluting. The sort of average man on the street or average person before they got to law school is like, that's not fair. Like, why should the factory get paid not to pollute? They're the ones causing the problem. But if you believe the law and econ people, they would tell you, no, it's cheaper to do this or that, and it's better for everyone. So these are examples of some, and in this case, you might not agree with that policy rationale, but you still need to understand it and be able to provide that analysis on your exam. I mean, what did you see coming up as policy?
Definitely a lot in torts. I specifically remember a discussion where we were talking about joint and several liability, where, a plaintiff can recover if there are multiple defendants and there's any ambiguity about, how exactly an injury happened. There's a lot of complicated law that can kind of come up around it, but that they can get a lot of money from whatever defendant that they can get into court and get the money from. And then the defendants can fight amongst themselves about who should be paying. And at first you're kind of like, well, that doesn't really seem fair. But then you kind of start talking about the policy of that the court is the most concerned about the plaintiff getting recovery. That's the most important thing. And then the tortfeasors can fight amongst themselves. And so things like that come up where you're like, oh, well, maybe that does sound a little fair, because it depends on what the court is most worried about. Also, it comes up in contracts. This idea that we have the freedom to contract is something that my contracts professor would talk about a lot. Where's the line at which the court will say, these contracts shouldn't be allowed, where we really have an underlying policy of that we should be allowed to contract for most things, but it turns out we're not allowed to contract for all things. So where is that line?
And this is also, obviously, like your personal political views and views of the world come into play on this, where I'm listening to you say, well, we should be allowed to contract for anything. I'm like, well, but what about situations where the little guy doesn't have equal power and, is being oppressed by this contract for whatever? So, these are the arguments that you'll have in class. And, your professor, I think one of the things you want to read during the semester is how much they care about these type of arguments, because some of them love them. Mm-hmm. And other ones, it's like they'll let people argue about, whether this is a contract of adhesion and the person who signed it should be protected from themselves or not. But ultimately, they're like, I just want you to know the law.
Right.
And in some cases, like on my torts exam, there was explicitly, he told us of the 3 questions, one of them would be a policy question. So there, obviously, a decent chunk of your study time needs to be outlining the different policy arguments that you've talked about in class.
And make sure that those arguments are part of your class notes. I think that's another mistake we see sometimes with students kind of ignoring the fact that they need to understand policy arguments, is they just think, oh, well, this is kind of fluffy, I won't write it down. in my
and again, like these are another set of examples of like what can just be totally maddening if your professor just lets people go on and on and on about their personal viewpoints on things, and you're like, God, I'm so sick of this. Like I can't, if this guy goes on one more time about whatever, I'm going to kill myself. But you need to be writing down what these arguments are, and one way you can do this is you can actually take a note, if it's in a highlighter or like handwritten notes, but literally make a note of what your professor says. So, bold, professor says, and your professor gives you 3 different pros and cons arguments. Mm-hmm. Those are the things you really want to be paying attention to. I mean, if it's just some guy's like, well, when I was on the Hill, like blah, 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 it's like, okay, fine, whatever.
And sometimes what will happen, another thing to focus on, is that a student will go off and kind of talk for a while. But then the professor will end that conversation and then say, did everyone hear what so-and-so had to say? And then they'll almost summarize what either the student did say or what they had hoped the student was saying.
Yes, their reinterpretation of what that discourse, what that long, like, drawn-out discourse on nothing was actually about.
Exactly. But I think the key to that is when your professor says, did everybody hear? That's exactly your cue to write it down. Because what they're trying to say is like, I'm going to throw you guys a bone. I know that there's no way that you wrote all that down because that was really difficult. So let me tell you what I think was important about what was said.
Right. And so, they might summarize it in terms of, while, as we've talked about, typically we think that people have the freedom to contract. However, there's some countervailing considerations, and those are X, Y, and Z. That's something you want to be writing down.
Absolutely. And I saw these full policy questions on some of my exams, definitely on my torts exam. My property professor was really into policy, maybe because she was an environmental law scholar. That might be because environmental law definitely has a lot of policy in it. But policy needed to be discussed on our property exam too. And so you might not even realize that some of these classes that you think may not have a lot of policy in them, because it's not, say, a constitutional law class, they might still have a lot of policy considerations that you might be tested on.
Right, and you even see it in something like CivPro that some people think is like, oh, it's just all about the rules. But I've seen CivPro exams where it was really about like balancing the considerations of fairness and efficiency for defendants and plaintiffs. That's a straight up policy decision.
Mm-hmm. And I mean, there's a lot of interesting policy around, and I hate CivPro, so the fact that I'm saying there's something interesting around it, but about why we drag people into different courts. When is it fair to drag a plaintiff from one place to another?
Yeah, absolutely. So these are things that pop up, and I think it's worth thinking about them as you're going through the reading and through your classes and kind of thinking, is this in the realm of policy? Because that's an argument, and in some ways that can also be a bonus point. So if you're talking about, well, which law should apply? There are 2 separate laws that could apply. Which one should apply? That's when you can bring in some policy arguments and really get those extra couple of points that could bump you up the curve.
And if you're not sure what your professor really wants you to take away from policy discussions in class, it's a great thing to go to office hours to talk about, because they might really clarify what they think the important policy arguments are, that you can take notes on what you're discussing in office hours, and then that might help you have a bit more focus as you're studying for exams.
And you can also look at what they're writing law review articles about, because that tends to tell you what they're interested in.
Very good point. I hadn't thought about that.
Yeah, no, I had my roommate's contracts professor literally gave them an entire exam that was based on his most recent law review article. So the people who had read that article in advance did a lot better. My
legal research and writing professor wrote our final exam on an issue that he had written his law review notes on. And I did find that in all of my research in our open universe memo, and that did definitely help my answer.
Yeah, it's worth spending half an hour for each class going through and seeing, like, what have they written on recently? Because that's what they're thinking about, and that's probably what they're going to test you on.
Exactly. All right, but with that, we are actually out of time. If you enjoyed this episode of the Law School Toolbox podcast, please take a second to leave us a review and rating on iTunes. We'd really appreciate it. And be sure to subscribe so you don't miss anything coming up in the future. If you have any questions or comments, please don't hesitate to reach out to myself or Allison at my email, which is Lee, L-E-E, at lawschooltoolbox.com, or Allison, A-L-I-S-O-N, at lawschooltoolbox.com. Or you can always contact us via our website contact form at lawschooltoolbox.com. Thanks for listening, and we'll talk soon.